It's about to start. Yes. Very good afternoon. Good evening, everyone. This is Dr. Sanket Charkha from Senior Institute, Savitribai Phule Pune University. We are starting with the subject of legal aspect of business, in which we have seen or we have understood about what are the various terms in respect to the Negotiable Instrument Act of 1881. In terms of Negotiable Instrument Act of 1881, we have seen various concepts or terminologies with respect to the Indian Paper Currency Act and the RBI, that is Reserve Bank of India Act of 1934 and Paper Currency Act of 1871. Further, we have seen what is the definition of negotiable instrument, which means a promissory note, bill of exchange and check payable either to order or to the bearer, and is always a transferable document which is in a printed or which is always in a written format. Further, transferable on delivery. Quickly overview now what is the meaning of negotiable and what is meant by endorsement. Features of negotiable instrument: it is completely free transferable, defects in title, remedy, right to sue, payable to order, payable to bearer, payment consideration, and presumptions as to negotiable instrument. Presumptions as to consideration, date, time of acceptance, time of transfer, order of endorsement, stamp, holder in due course, and proof of protest. Instruments which have been recognized by statute: bill of exchange, check, promissory note, and as per the usage or customs of trade are banknote, share certificate, share warrant, dividend warrant, deeds, and government promissory notes. Types of bill of exchange: types of the negotiable instrument as per the recognition of statute are bill of exchange, promissory note, and check, and hundis. Hundis are no longer into existence and not in the syllabus, hence we are not taking these particular perspectives. Next thing, essential elements of, as you have seen, essential elements of a valid contract or essential elements of a sale. In this same case, you have essential elements of a negotiable instrument also. What are the various concerns? What are the various factors a negotiable instrument must have? Always a negotiable instrument must be in writing. There must be specified to either 2, 3, or 4 parties. It must be a specific order to pay. It is always unconditional. It is signed by a certain maker. That is the person who is preparing the negotiable instrument. Always the person who is directed, that is drawee, must be certain. There should be a certain money, that is a consideration as a major perspective, and the currency must be denominated. Whether the negotiable instrument is drawn in rupee, dollar, euro, yen, pound, which type of currency you are looking for. Payee must be certain, that is in case of a check that has been drawn, which has been prepared, the payee, that is which banker is to make the certain payment, it also must be certain. And lastly, stamping. So whenever a negotiable instrument is prepared or it has been forwarded by one person to another person, so in this case stamp duty has to be paid by the specific parties. In case of negotiable and bill of exchange, the stamp duty is at least 1 rupee, but in case of a check, the stamp duty differs from bank to bank. A bank may charge you a stamp duty of 2 rupees, 2.5 rupees, 2.3 rupees, 3 rupees, and so on. So it keeps on differing. Promissory note, according to section 4, the Negotiable Instrument Act. Now, definition of promissory note: it is an instrument in writing containing an unconditional promise. So so promissory note is just a promise you may fulfill or you may not fulfill, containing an unconditional promise undertaken, signed by the maker to pay certain sum of money or to the order or to the bearer of the instrument. Format of the negotiable, the format of the promissory note, that is after 3 months after date, I promise to pay. So it is just a promise and it may be fulfilled or it may not be fulfilled. Parties to the promissory note: usually there are only 2 parties, but a third party can arise at this stage whenever a particular person is holding a certain instrument, and the particular person who is holding the instrument is called as an holder, and in this case then the parties become 3. So maker, payee, and holder are the 3 parties to the negotiable instrument. Types of promissory note: payable on demand, payable after date, joint promissory note, and joint and several promissory notes. Then further we have seen what is bill of exchange, a negotiable instrument in writing containing an unconditional order. So here specifically it is an order and it has to be fulfilled or it has to be complied with. So here in this case, a negotiable, if a bill of exchange is not honored properly, then accordingly the legal action can be taken against the person who is not honoring that instrument. Format of the specimen of bill of exchange: parties to the bill of exchange, drawer, drawee, and payee. So if a bill of exchange is been discounted, 164. If the negotiable instrument is not discounted, then accordingly we can say that a bank will make the payment, and accordingly the 3 parties are into existence, which are either the drawer, either drawee, or the payee. Types of bill of exchange: demand bill, time bill, inland bill, foreign bill, trade bill, and accommodation bill. Definition or meaning of a check: a check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise on demand. So unless and until the party demands, unless and until the party approaches a particular bank and deposit that particular check, the payment will not be made to a certain person. So in this case, a check is always payable on demand. So a party has to demand a certain payment, and then only the payment for a particular check can be done. So if it is not been presented for the clearing purpose, then you will not get the payment of that respective check, whatever you have prepared for. This is the specimen of check. I have just drawn it in a particular concern. Now you must, everyone as on today is having a checkbook, and you can refer which type of format. So different, it differs from bank to bank. It differs from different colors, logos and signs and so on. So accordingly, there are different types of check that are into existence. Now the parties to a check: maker, drawee, payee, holder, endorser and endorsee. These are the different types of parties to a check. Now the types of check: open check, cross check, bearer check, order check, stale check, post-dated check, account pay check, non-negotiable check, and check which is crossed more than once. So all these things we have seen in detailed explanation with respect to promissory note, bill of exchange, endorsement, due date of endorsement, legal representative, subject to provisions, exceptions to the rule, so effect of endorsement and so on. So we'll not go again in detail. Contrary is proved, the following presumptions shall be made. So presumption as to consideration, as to date, as to time of acceptance, as to transfer, as to endorsement, and as to stamping. That the holder in due course. What is the meaning of holder? What is the holder in due course? And what are the various crossings with respect to a check perspective? Now moving with the next slide is the concept of check. Check, there are two types of check: a check which is not having any condition, which is not crossed, is called as an open check, and a check which is crossed by drawing two parallel lines on that particular check, then it is called as an crossed check. Different types of crossing. Crossing can be defined under three categories, that is general crossing, special crossing and restrictive crossing. In terms of general crossing, there is and company, non-negotiable and company. These are the three types of general crossing. Special crossing, that is account pay, Bank of India, and non-negotiable Bank of India. Another three types of crossing. And restrictive type of crossing is account pay only SBI. So here in this case, in terms of restrictive crossing, the account, the payee, that is the bank, can make a certain payment, and only SBI is authorized to make the payment for this particular check. So this is the type of State Bank of India type of check that is into existence. Essential elements of a check. So what a check must include, or what a check must have. First thing, always a check must be in writing. It must have an expressly order to pay. It must be signed by the drawer. It should have a specific order to pay. So express order to pay and order to pay means either first thing by the drawer and second thing by the drawee. Certain sum, always the amount that has been written on check, that is in words and in figures, it must match. And accordingly, if you are writing 10,000, then accordingly 10,000 and TE and THUSAND rupees only. In this way, both the amounts must match. Three parties: the person who is preparing a check, the person who is accepting the check, and the bank which is making the payment. So drawer, drawee, payee. So these are the three parties to a check. Specified banker, always a specified banker must be applicable, and only the payment of a check can be received by a specific bank only, and no other person or no private individual is allowed to make the payment of check. And lastly, payable on demand. So unless and until the parties demand for a certain payment, the payment for a check cannot be done, and hence it is always payable on demand only. Next is liability of parties in negotiable instrument: liabilities of the drawer, liabilities of the drawee, liabilities of the maker or payee, then liabilities of endorser or endorsee, liability of holder in due course, liability of principal debtor, liability of acceptor, and lastly liability of a specified banker or authority. Types of endorsement: blank or general, special or full, partial, restrictive, and conditional. Further, we have seen what are the various different types of endorsement, that is sans recourse, facultative, sans prias, and contingency. Now moving towards the last concept, that is the understanding of when a dishonor of a negotiable instrument, that is when a negotiable instrument can be dishonored. Now dishonored in the sense, the either any of the parties is not accepting the negotiable instrument in a specific period of time, and when you cannot get the payment for that negotiable instrument. First thing, drawee do not accept within 48 hours. So whosoever is the, now who is the particular person who is a drawee? The drawee is a particular person who is accepting the negotiable instrument. The person who is preparing the negotiable instrument is called as a drawer, and the person who is accepting कि जिसको वो negotiable instrument मिलने वाला है, the one who is receiving the particular money, is called as a drawee. So if the drawee does not accept the negotiable instrument within 48 hours, then the negotiable instrument can be dishonored. So a party has to take into consideration, a party has to confirm within 48 hours about what is the terms and conditions and whether he is accepting the negotiable instrument or not. So if he is not accepting within 48 hours, then the negotiable instrument gets dishonored. Several drawees and one or more do not accept. Now in a particular negotiable instrument, what we have seen, that there can be several number of parties also, that is there can be either 1, 2, 3 or 5 or 10, several number of drawees also. So if any one of the party to the drawee, or any one of the parties whose name is mentioned into that particular negotiable instrument, if they are not accepting the negotiable instrument within the specified time period, then accordingly the negotiable instrument gets dishonored. So all the drawees, if there are several number of drawees, each and every drawee must accept that negotiable instrument, and hence it is of major consideration that the negotiable instrument must be honored, and in order to be honored, all the parties to the negotiable instrument must agree or must accept the negotiable instrument in this specific format within specific time duration only. Negotiable instrument is not accepted. So if there is a one person or the one right to the negotiable instrument, then accordingly, if one party is also not accepting, then also the negotiable instrument gets dishonored. Draw is incompetent to enter into contract. So here in this case, you have seen which are the, now in terms of chapter number 1, we have already studied which are the parties which are competent to enter into contract. So if any of the party who is not incompetent, who is not competent to enter into contract, then also a negotiable instrument gets dishonored. Who are those parties? A particular person who is of minor, that is below the age of majority, unsound mind, disqualified by law, and so on. So these are the various parties who are incompetent to enter into contract. So if any of the person is been identified and he becomes drawee, then your negotiable instrument gets dishonored. Drawee gives qualified acceptance. Now, what is the meaning of qualified acceptance? That is based on a certain terms and conditions. So always a negotiable instrument must be free from any conditions, free from any terms, and if any terms and conditions have been laid down on a particular concern or a particular negotiable instrument, then also a negotiable instrument gets dishonored. And lastly, drawee becomes a fictitious person. Fictitious person is a person who cannot be identified at every stage or every point of time. So at any stage, if you feel that you cannot identify who is the drawee, who is the stage, who is the payee, and how the negotiable instrument contract has come into existence, and for example, you have prepared the negotiable instrument and there is no existence of drawee also, that is, he is not neither accepting or nor giving you a certain communication of your acceptance also. So in this case, the drawee becomes a fictitious person. अगर कोई लापता हो जाता है, so in this case we can say that a negotiable instrument gets dishonored. Why? Because it is not been accepted and it is also not presented for payment also. Now, bouncing or dishonor of a check. So what are the various terms and conditions in which your check can get dishonored or your check can bounce? First thing, irregular endorsement. So here, if a check is not been endorsed properly, if the check is not endorsed in a proper way or in proper format that has been mentioned, then also your negotiable instrument or your check can get dishonored. Now, what is the condition of endorsement? You have to sign on either on the front or the back side of that particular check, and it should be unconditional. So if a particular check is being prepared in an unconditional format and that particular condition format is not able to be fulfilled or not able to be complied, then your endorsement becomes irregular and the bank may refuse to make the payment for a respective or the interested party. Irregular endorsement also means that is what is the consideration, that is you have to draw two parallel lines on a particular corner of a particular check, and if you are not drawing two parallel lines and a certain design has been drawn, then also the negotiable instrument gets dishonored. Material alteration, if there is certain material alteration in terms of a check, then also the negotiable instrument gets dishonored. Now, for example, a particular check which is named as now pay Sanket so and so amount of rupees 10,000. Now, in this concern, what happened? We cannot identify what is a Sanket or which person is specifically mentioned. So what do? I can mention it as Sanket Charkha also. I can mention it as Sanket Gaikwad also. I can mention it as Sanket Bankar also, and so on. So what is the concern? Material alteration. If any changes in the material alteration has been made, or if the name has been changed on a particular check, then accordingly we can say that the bank can dishonor the check of this particular concern. So there should not be any scratching, rewriting, or overwriting on a particular check also. One check has been drawn for rupees 10,000, and whatever for one what you have done, you have written it as 7. So one can be done as 7, and accordingly it can be called as a material alteration. So if any alteration, if any rewriting or overwriting is being found on a particular check, then a bank may refuse to make a certain payment, and accordingly it can get dishonored. Loss of a check. So if your check gets lost and accordingly you are given a certain notice to the bank of your loss of check, then accordingly the bank may refuse to make a certain payment, and accordingly the check gets bounced. Stop payment, if a particular party has given a certain order to the bank for the stop payment of check also, and if the party who has received that particular check present it for the payment, then also your check gets dishonored, and accordingly the bank refuses to make the payment. Garnish. Now, garnish means specifically means a order which has been passed by a certain court. So if a particular court specifically gives a certain order with respect to non-payment of a certain amount, then also the check can be dishonored or the check can get bounced. Death notice of a drawer. So the drawer is a particular person who has prepared or who has drawn this particular check on a certain person. So in this case, if the death of the drawer is into existence, and if the person who has prepared that particular check gets insane, or if he gets insolvent, or if he dies, then in this case also the bank can refuse to make the payment or the check can gets bounced. इंसैनिटी, अगर कोई भी आपका जो ड्रॉवर, द पर्सन हु हैज प्रिपेयर्ड अ चेक है बिकम्स इंसेन, कि अगर वो पागल बन जाता है, देन ऑल्सो द चेक कैन बी रिफ्यूज फॉर मेकिंग द पेमेंट. असाइनमेंट ऑफ क्रेडिट बैलेंस. सो असाइनमेंट ऑफ क्रेडिट बैलेंस मीन्स अगर आपके अकाउंट में बैलेंस नहीं है, So if the check has been drawn for rupees 10,000 and if the balance in your account is rupees 9,000, then based on the assignment of the credit balance, that is non-availability of the funds into your account, the check can get bounced or the bank may refuse to make the payment. And lastly, defecting title. So if the person who is preparing the check and the person who is receiving the particular check, if the defecting title is been obtained, if we cannot identify about how the check has been into existence, so in this case also, if we're based on the consideration of the defecting title also, we cannot identify about how a check has come into existence. The person who is preparing the check is called as a drawer, and the person who is receiving the check is called as a drawee. So based on those considerations also, if the title of the goods, if the title of the commodity, or if the title of person is not into existence, then based on the consideration, we can also say that there is a defecting title of those goods and services. And lastly, notice of closure. The notice of closure, if a particular person, that is a particular drawer, has given a certain consideration to a bank, or a certain notice has been given with respect to closure of a particular account, then accordingly, if the particular order has been passed by a respective bank or particular action has been taken for closing of that particular account also, then also we can say that the bank can refuse to make a payment, or the check gets dishonored, or the check gets bounced by a particular bank. Now, what are the various terms, or what are the various issues when banker may refuse to make the payment? So, what are the various terms and conditions in which the bank may refuse? So, you have presented the check, but the check is not accepted by a particular bank, or the bank refuses to make the payment. So, let's look at those terms and conditions in which the bank is refusing to make the payment. First thing, insufficient funds. So if a particular bank identifies that there are insufficient funds into your account, then the bank may refuse to make a certain amount of payment to the interested parties. Whether the check is correct or whether the check is wrong, if the terms and conditions in the check are found to be very effective, very perfect, then also still in this case, the bank may refuse to make the payment. That is, the check was drawn for rupees 10,000, but the balance, that is sufficient fund that have been required into account as rupees 9,000. Then in this case, we can say that based on the consideration of insufficient funds, the bank may refuse to make the payment to the particular person. Funds not applicable. That is, what you have done, you have prepared the check of rupees 10,000, but the currency that you have mentioned is in dollars, and the check in dollar is not applicable in India. So in this case, what happened? The bank may refuse to make a certain term of payment. Funds not applicable. That is, you have mentioned the amount of rupees 10,000 and the balance in your account is just 0. So in this case, if the funds are also not applicable, or if you have misinterpreted the particular consideration, then accordingly the bank may refuse to make the payment. Proper place of presentment. If a particular check has been identified of a certain consideration with respect to a proper place, that is payable in Pune only, payable in Maharashtra only, payable in Jammu only, payable in Delhi only, then based on the consideration also we can say, or we can identify that a proper place of presentment, if it is not being made, then also the check can be refused. The bank may refuse to make a certain payment of check. Presentment after the banking hours. Now, as per the standard norms of standard conditions, every bank has displayed its banking hours outside the premises. That is, the bank is open from 10 to 4, 11 to 5, 10:30 to 4:30, and so on. So, if for example, if standard standard time of a particular bank is 10 to 4, and if you go in a particular bank at at 4 p.m. or 4:01 p.m. or 4:05 p.m. or 4:30 p.m., then accordingly, after the banking hours, the bank cannot accept a particular check, and hence we can say that the bank may refuse to make a certain payment. That is, if you go either at 9:30 a.m., the bank will not make you payment. You have to go between 10 to 4 only, and then only the payment for that particular check can be done. Stale check notice, that is, if you have received a certain notice by a respective drawer that your check has been lost, and accordingly a third party comes and demands a certain amount of payment, then also the check can be dishonored and you will not get the payment, and the bank will refuse to make a certain payment. Post-dated check. You have prepared a check. The particular party has prepared a check as on today, but the date that has been mentioned is of a certain future date. That is, today the date is 12th of March, but the date on the check is 12th of April. So here in this case, on 12th of March, you will not get the payment for the particular check. You have to approach to the bank on 12th of April only, and then only you can get the payment. So a post-dated check can also did not get a payment at a certain concern, and the bank may refuse to make a certain payment. Undated check. So if a particular check is also not dated properly, if all the details are not been mentioned very properly, then also the bank will refuse to make a certain payment. And lastly, expired check. That is, if a check becomes expired. So if the check has been prepared, that is the check has been prepared as on today, that is 12th of March, and when will it get expired? It will get expired on 12th of April, May, and June. So 12th of June, that is 3 months is the time duration for an expiry of check, and accordingly, if you approach to a particular bank on 30th of June, then accordingly the bank will refuse to make a certain payment based on the consideration of expiry due date or the of that particular check. And lastly, signature mismatch. So whatever signature has been made on a particular check, if it does not match with their portal or if it does not match with their database or that particular record, then accordingly, based on the consideration of the signature mismatch, the bank may refuse to make a certain amount of payment. Now, discharge of negotiable instrument. So when a negotiable instrument gets discharged, or when the liability of a negotiable instrument comes to an end. First thing, payment in due course. If the payment for the negotiable instrument is been made in a specific time period, then accordingly we can say that the negotiable instrument gets discharged, and accordingly the parties to the negotiable instruments are completely out of the purview or out of the origination. Next consideration is the by cancellation. So if any one party to the contract cancel the negotiable instrument based on a certain consideration that they do not want to honor the negotiable instrument, so hence we can say that the negotiable instrument is discharged, and accordingly by cancellation of a certain terms and conditions, by cancellation by the either one party to the contract, either the drawer or either by the drawee, the negotiable instruments gets discharged. Party primarily become holder. So if any one of the party to the negotiable instrument becomes primary holder, that is by the endorsement perspective. That is, you have prepared a particular check, but it gets transferred to one person to another person, and accordingly it reverts back to the original party. Then here in this case we can say that the negotiable instrument gets discharged, and accordingly the payment cannot be made. Express waiver, either one party to the contract, the person who is preparing the instrument or the person who is receiving that particular instrument, if they waive off, that is, if they take back their respective liabilities, or if they take back the respective payment terms and conditions, then accordingly we can say that the negotiable instrument gets discharged. Discharge by simple contract. So discharge by simple contract specifically means a certain consideration wherein both the parties come together and they mutually agree for consideration or for concluding of the respective roles, liabilities and considerations. Then accordingly, by the discharge of simple contract, the negotiable instruments can come to an conclusion, or the negotiable instruments come to an end, the liabilities of the parties gets discharged. Now the discharge of individual parties. So individual parties, how does their liability gets discharged? First, by the payment person. So if the drawer and drawee receives the payment and makes the payment to the respective of the interested parties, then accordingly we can say that the discharge of parties is into existence. The person, that is the person who has prepared the instrument, he makes the payment, and the person who has received the instrument, he receives the particular payment. Then accordingly by the payment terms and conditions, the parties to the contract gets discharged. By cancellation. So if any one of the parties to the contract cancel the respective instrument, that is either the check, promissory note, bill of exchange, if it has been cancelled, then also the parties to the negotiable instrument gets discharged. By release of any one party. So if any one party to negotiable instrument withdraws the respective liability, that based on the withdrawal of that particular liability also, the parties to the negotiable instrument gets discharged. Allowing drawee more than 48 hours. So if you allow a particular drawee for acceptance purpose, for that is for more than 48 hours, then also the parties to negotiable instrument can get discharged, and accordingly hence we can say that the discharge of the parties into existence. Taking qualified acceptance. So now what is the consideration, what is the essential element, that the negotiable instrument must always be unconditional. So unconditional means based on the certain terms and conditions. So if certain terms and conditions are being laid, and if the negotiable instrument becomes conditional, it becomes qualified, then based on the consideration of the qualified acceptance, the parties to the negotiable instrument gets discharged, and accordingly we can say that there is no liability that is into existence. Giving notice of dishonor. So if a notice of dishonor is received either of the drawer or either of the drawee, so based on those consideration also, the parties to the negotiable instrument gets discharged. Non-presentation for acceptance, that is within the specific time period or within the specific time duration. Promissory note, bill of exchange, we specifically mention a time, that is 3 months, 6 months, 1 year, 25 days, 40 days and so on. But in case of check, it is specifically mentioned that the check has to be presented for the payment within the duration of 3 months. So if the parties to the contract, if they are not making the presentment of negotiable instrument within the specific time period, then we can say that the parties to the negotiable instrument gets discharged. So either the drawer, either the drawee, or either the payee, or either the maker, everyone party to the contract gets discharged, and accordingly their liability comes to an end. Delay in presenting of negotiable instrument. So if the negotiable instrument is not presented in a specific time period, if it is been made delayed, then the negotiable instrument gets discharged, and accordingly here the liability comes to an end. No proper banker. So if the banker that has been prepared, it is not been specified, if it is not proper, it cannot be identified properly, then hence we can say that the parties to negotiable instrument gets discharged. And lastly, material alteration. So if there is material alteration in any of the negotiable instrument, that is either the name, either the crossing, either the amount, either the signature, either the party, that is the name of the drawer or drawee, if there is a certain alteration in material alteration in the amount of either in the amount or either the name of the parties, then accordingly the parties to the negotiable instruments gets discharged, and the liability of all the parties come to an end. Okay. That's all for today's lecture, and we come with the end of third chapter, that is Negotiable Instrument Act. Thank you so much everyone for joining. Good day.